wanted to join. However, unfortunately, the session is being closed for registration. So we also invite your comments and questions, all right? If you have any, please use the chat box placed at the right side of your screen. So if you think of any question to the speakers at any point throughout the session, just type it in there, right? So however, I'm going to consolidate all the question and pose it to our speakers at the end of the sessions. And I actually highly recommend holding your question for the discussion at the end of the event, all right? So you can just pose the question yourself to the speakers. And I urge all participants to mute your microphone throughout the session to avoid disruption, right, when the speakers are giving their speeches. So we actually will be running a live discussion session at the end of the last speaker, all right? Feel free to unmute your microphone during that session. So if you have any question, right, or you have any queries whatsoever, please pose it directly to our speakers. Now, before that, please state your name and also your affiliation. And the attendance link will be provided and released at the end of the event. All right, please make sure you fill in all of the necessary information to ensure that we are able to secure your CPD points and also your training hours. All right, so basically our goal today is whatever your role in this construction industry, all right, that you will come away, inshallah, with something, albeit a new idea, a fresh perspective, a new strategy even, to that you can actually apply in resolving disputes. All right. So I thank you for your cooperation and may you have a fruitful session ahead, inshallah. All right. So before I invite our first speaker, allow me to lay down the agenda for today's webinar. Right. So I'm going to share my screen with you. Right. Okay. So today's agenda, we are going to kick off the webinar with a speech from our first speaker, Associate Professor Technologist Dr. Zulhabri Ismail, talking about arbitration from procedural law perspective. And then we are going to continue with the second speaker, which is Surveyor Technologist Adi Shambarin, on the topic of an overview of adjudication and mediation in the construction industry. And we will open a discussion session to answer all of your questions at the end of the second speaker. All right. So if you have any question, please hold it in, all right, and pose it directly to our speaker at the end of the session. All right. So moving along to our session. So ladies and gentlemen, while most of us may have an idea on litigation procedures, right? So we are familiar with that. However, not many may be aware on what we call an alternative dispute resolution process that is called arbitration, right? While sharing the same objective as court procedures, arbitration is actually a private process that is done without a judge, right? In the next 40 minutes, you will learn about arbitration from the procedural law perspective. So it is with particular excitement that I am pleased to introduce our first speaker. Associate Professor Technologist Dr. Zulhabri Ismail is an Associate Professor of Construction Management and Law, right, from the Faculty of Architecture, Planning and Surveying, UITM. Dr. Zulhabri holds a Doctor of Philosophy in the specialism of the Built Environment Construction Law and is legally qualified as an alternative dispute resolution practitioner. He is a panelist, adjudicator and mediator. So Dr. Zulhabri often being appointed as construction industry expert advisor and consultant for construction law, contract administration, dispute resolution, and matters on adjudication proceedings. And he is also a fellow of the Asian Institute of Alternative Dispute Resolution. All right, speaking to us on arbitration from procedural law perspective, please join me in welcoming Associate Professor Technologist Dr. Zulhabri Ismail. Dr. Zul, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Thank you, Miss chairperson, Ms. Suhaida. Boleh dengar tak suara saya? Clear? Hello?
Boleh, Doktor.
Okay, alright. Thank you for such lengthy introductory notes. Basically, as you all know, the purpose of this session is to cater on the alternative dispute resolution (ADR). Yeah, and the session will be conducted bilingual lah. Yeah, so maknanya that meaning that feel free to ask me in bahasa, and my lecture also will be somehow mixed between bahasa Melayu dan juga Inggeris. So can you see my slide now? Tu? Clear kan? Nampak tak slide saya? Okay.
Okay.
Okay, dapat? Okay.
Yes, clear.
Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin wassalatu wassalamu ala sayyidil mursalin wa imamil muttaqin wa ala alihi wa ahli baiti wa sahbihi ajma'in. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. So Madam Chairperson, Mr. Chairperson, my counterpart, Surveyor Eddie, yeah, and also the rest of the participants. Thank you for signing in for our first webinar. So this basically the webinar has been divided into two parts. Sebenarnya has been divided into two parts. So this is considered as the first part. So in the first part, we are going to discuss briefly on what is the methods under the umbrella of ADR, and we are going to zoom in terms of the procedural aspect. Sebab if you talk about dispute resolution, there are two different legal perspective. Yang pertama, what we call it as procedural law, yeah, and the second one is very much on substantive law. So the purpose of this presentation is to cater for the substantive, for the procedural law aspect. However, I'm willing to take any question if any of the participants who wanted to ask about the substantive part of the ADR. Maknanya substantive ni maknanya we're talking about the content wise, in terms of contents, the issue, the disputed issue. Itu pun I'll try my best to answer the question if there is any question on that. Tapi the purpose of this session is to cater on the procedural law. Sebab kalau if you're talking about the substantive, I'm supposed to cite case law, and the discussion is going to be a bit lengthy on that matter. So to begin with, to begin the session is of course lah kita kena mulakan. We need to start with definition. What the definition of ADR, alternative dispute resolution. Kalau you tengok, if you look at the first word, the first words under the ADR is alternative ataupun alternative. I think it's referred to alternative. Alternative to what basically? Alternative to litigation ataupun court system lah. Yeah. So anyhow, court is still the having the higher rank as compared to alternative dispute resolution. Yeah? So maknanya people what we call it is if possible we try to go for litigation ataupun court, but somehow or other due to various reason the parties are given the opportunity to resolve their dispute by way of alternative means lah. Yeah, so arbitration is one of them lah. Yeah. So basically, when we talk about ADR, under the umbrella of ADR, we have numerous of methods. So I would like to name a few. Arbitration, adjudication, dispute board, expert determination, mediation, stroke conciliation, or hybrid. Hybrid means a combination of any of those dispute resolution. But this no means conclusive. Ada lagi mini trial, ombudsmans. There are numerous of other methods under the umbrella of ADR. Tapi for the purpose of presentation today, for the purpose of our discussion today, we are going to zoom in into three most dominant ADR methods, which is arbitration, mediation, dengan adjudication. Dominant within the context of construction industry lah, But if any of you wanted to ask question on the dispute board or any other ADR which are very much applicable for construction under the construction contract, feel free to ask. But as I mentioned, we are focused on the most dominant ones, which is, as I mentioned, mediation, adjudication, as well as arbitration. This is the overall content of my presentation. Arbitrability, the governing law. Governing law maknanya apakah undang-undang yang menjadi underpin the arbitration. The arbitration governing bodies, badan-badan yang govern arbitration, soft laws ataupun rules of arbitration, because basically arbitration is governed by Arbitration Acta, Arbitration Act, which is the statute for arbitration. Even so, apart from that, there are other rules. We call it soft laws. Soft law ni sebenarnya bukan akta lah. It is not law per se, but it is soft law is to to provide the procedure aspect, to the procedure on how the arbitration supposed to be commenced and supposed to be proceeded. Then kita akan going to focus on a bit of procedure of arbitration, dan juga also we're going to cater for provisions under the standard form of contracts, dispute resolution under the standard form of contract. This is one of the key aspect of my presentation today, And I'm going to discuss briefly on few selected cases on arbitration. I know that looking at the demographic of our participants, majority, I think almost all of us are from the construction background. So I think we are not very much keen into the cases, tapi it's better if I can just briefly give you some of the case law on arbitration. Then I'm going to conclude my presentation by discussing about just a bit on the rules of court under 2012. Rules of court of 2012 to see that how court system, I would say, the court system is able to support how the court system support the arbitration and alternative dispute resolution. So rules of court under section under rules 69 and 69A. Very brief. Okay. So arbitration. Sundaraju mentioned that it is an extrajudicial method. Like arbitration has been used since ancient times. So maknanya arbitration ni is considered as a big brother lah under the umbrella of ADR. Arbitration has been around since early 2000 in 90s in Malaysia. And the first statute on akta yang pertama on arbitration is Arbitration Act 1952 lah. Then later we have 2005. Even so, the Arbitration Act 2005 has been amended twice. Secara majornya lah, has been amended twice, which is on somewhere in 2011 and also somewhere in 2018. So dua tahun ni adalah where the arbitration akta telah berubah secara agak drastik. And dan perubahan ni, those changes are very much more friendly towards the arbitration users sebenarnya. They are more friendly towards arbitration, meaning that dia lagi sesuai untuk diguna pakai dalam construction. Sesuai in terms of what? Sesuai in terms of, for instance, arbitration agreement can be in writing regardless of any forms. That's number one. And number two, which is the court is very much the court the role of court has been minimized. Tentu. Tapi the supporting role tu ada, supporting role of the court to support arbitration tu memang ada. Okay, now definition of arbitration, I think to make it short is just to solve ataupun to refer the dispute to one arbitrator or arbitrator, and this arbitrator is supposed to resolve to come up with award lah ataupun kita panggil decision. Decision ni sebenarnya dalam akta kita panggil, we call it as award. When we talking about arbitration award, mean we are referring to the the end result of the arbitration itself. Arbitration is a procedural law. Yes, arbitration is a procedural law. People sometimes confuse between arbitration as a law itself. Arbitration is merely a procedural law. Dia hanyalah procedural law. What does procedural law means? Maknanya you are bound by the procedure. Somehow, ramai juga klien tanya saya, boleh tak kita cut short? Can we cut short some of the procedure? Boleh tak kita straight away submit statement of claim, statement of defense and so forth. Sebenarnya tidak boleh, because arbitration or same goes to adjudication juga, whereby it is a procedural law. We are bound by the procedure. Kalau katakan the act mention about you must come up with a notice, to concur, to the notice is counted for. Without that notice, the process of arbitration might fail. Might fail in the sense of somebody, the other party might challenge in court lah. Itu maksud saya. The parties also can decide on the appointment of arbitrator, the rules and procedures. So arbitration is quite flexible lah as compared to the court system. It's quite flexible, in a way that the parties may decide on the appointment of arbitrator, and also the party may decide on the selection of rules and procedure. You nak guna procedure mana? For instance, you nak gunakan in Malaysia, badan yang the governing bodies on arbitration yang agak established is of course lah AIC, ASEAN International Arbitration Center. So ASEAN Arbitration, or in short AIC, has their own rules, arbitration rules. Similar go to PAM pun. PAM pun ada juga arbitration rules dia. So if the party agree to use AIC or even PAM rules, so therefore you have to follow the rules and procedure that has been mentioned under that particular rules. But of course it's subject to the arbitration agreement itself lah. So arbitrability and nature of dispute. Ramai orang tanya, what sort of dispute that can be referred to arbitration? So basically, as long as policy provides, public policy provides. So these are some of the dominant arbitrability ataupun nature of dispute. Arbitrability maknanya arbitral, you are able to arbitrate. Itu maknanya. So the dominant ones are energy, oil and gas, maritime, sports, investment, corporate, banking and financing, construction, or even torts. Tapi if you look at the number of cases, the majority of arbitration cases are very much construction cases. Construction cases sebenarnya. If you look at the majority of cases, majority are construction cases. If you look at arbitration books, arbitration references by Sundar Raju and a few other I would say superstar in arbitration, the majority of case law are very much construction cases. Kenapa jadi macam tu? Why is it so? The answer is simple. Number one, because we require somebody who are having having a strong background in construction. That's why we believe in arbitration. And number two, because the arbitration agreement tu ataupun clauses on arbitration tu are very much available under the contract. Maknanya if you look at PAM, under PAM there are arbitration provisions. Under PWD form of contract there are arbitration provisions as well. So and if you look at international construction contracts pun, oil and gas. Oil and gas are the strong believer on arbitration. Sebab apa? Because oil and gas ni dia ada, I would say, as it involve maritime issues apart from normal construction lah. Construction of the oil and gas platform and so forth. Dia ada elemen-elemen of oil and gas. Dia ada elemen-elemen of maritime. Maknanya international law lah. So if international law, if the industry governed by international law, so arbitration is the most appropriate dispute resolution. That's why if you look at oil and gas, they are very much into arbitration. So the governing law, okay, kita ada sebelum ni, before Arbitration Act, kita ada Arbitration Act. Before Arbitration Act 2005, we have Arbitration Act 1950, 1952, ataupun Act 93. So biasalah kita masa mula-mula, this is considered kita punya the maiden arbitration act lah in Malaysia, yang mula-mula. So bila kita masa tu kita mula-mula I would say embark into arbitration, there are active judicial intervention, active judicial intervention. Maknanya the court is supervising the arbitration procedure, macam tu lah. So as we go along, as we become more, I would say, mature, then we try to not get rid of the court ataupun try to get rid of the judges. Bukan, the role of court is becoming, instead of supervisory, dia become like supporting role. The court becoming a supporting, having the supporting role to ensure that the arbitration can be progress efficiently. Dia gitu. So anyhow we still need court, sebab arbitration ni dia still perlukan court to, I would say, to support. Many people always say that kalau macam tu better kita pergi ke court. Itu the people punya understanding. Sebenarnya the court is more on supporting role. So mean that if you have arbitrated, you dah arbitrate, the award has been produced by the arbitrator, then what's next? The next move is to enforce, kuat-kuasakan. So untuk kuat-kuasakan award tu, then you need court to support. Same goes to international arbitration juga. One of the strong character of arbitration, one of the strong characteristic of arbitration is it I would say, inter countries. Meaning that kalau you ada arbitration, if you arbitrate in Malaysia, and one of the party is in UK, then you can enforce, kuat-kuasakan award to the UK or any other more than 150 countries yang berdaftar dengan New York Convention. Itu kekuatan arbitration yang tidak ada pada mana-mana mahkamah. Itu kekuatan dia lah. Then later Arbitration Act has been repealed by Arbitration Act 1950 has been repealed by Arbitration Act 2005. So I'm not going to dwell further detail on the Arbitration Act. So if you look at my slide, my slide is quite extensive lah. If you want to have my slide, feel free to contact me, or I may provide the slide to the admin. So admin may send over to you. So I'm not going to delve further on the Arbitration Act itself. Suffice for you to know that the law governing the arbitration is Arbitration Act, and both of the domestic and international arbitration is governed by the Act as well. Apa maksud international and domestic arbitration? International arbitration means when you have one of the parties which is not from Malaysia, national arbitration lah. Then another one is domestic. Domestic when both of the parties are from Malaysia. So kita panggil domestic dan juga international. So this is the statute. The statute, the Akta Timbantara. So the latest amendment is in 2018, as I mentioned to you early on. Arbitration is dia punya, I would say, standard form for arbitration lah. In Malaysia, sometimes in construction industry kita we are familiar with standard form kan. So ancestral model law ataupun kita panggil model law lah in short, dia ini the model law is the standard form for arbitration law itself, yeah. So dia dikeluarkan oleh United Nations. So the changes made to the Arbitration Act is closer to the modern model law itself. Mean that kita follow international punya standard in terms of the arbitration. So if you look at in Malaysia kita ada EIC. EIC antara among I would say among the most reputable ataupun respectable arbitration center lah. Apart from kita ada Singapore, kita ada Singapore, kita ada Hong Kong, Hong Kong International Arbitration Center HKIAC, kita ada Malaysia which is under EIC. Kenapa EIC, ASEAN Institute of ASEAN International Arbitration Center? Previously it is KLRCA. The reason being is to ensure that to make Malaysia known by the international participant. Itu antara reason dia. Then that's why if you look at the Arbitration Act kita is moving towards international ataupun follow the international standard, ya. Features of Arbitration Act. Feature yang antara yang penting yang saya nak mention dekat sini adalah section 9 arbitration agreement, ya. Sebab you cannot have arbitration without arbitration agreement. Ya, you kena ada arbitration agreement ataupun arbitration clause in your contract. Dia tak macam SIPA, adjudication. Adjudication is different. Adjudication SIPA adalah substantive plus procedure law. Arbitration is a procedure law. Dia lain. Itu beza dia. Ya, SIPA, adjudication, dia ada, kita panggil substantive plus procedure law. But arbitration is merely procedure law. Itu beza dia. So meaning that procedure, one of the most iconic or important features of Arbitration Act is you need to have arbitration agreement in your contract. Without arbitration agreement, parties cannot arbitrate. Ya, itu dia punya theoretical, from the theoretical perspective. Ya, but of course you can agree to refer to arbitration once the dispute occur lah, of course. Ya, tapi kalau fikir logik dah pula kan, you dah bergaduh, boleh ke pula you kata can we agree to arbitrate? Agak sukar. It's quite difficult to agree on something once you are having dispute. So the one of the salient features of Arbitration Act 2005 is to recognize any form of arbitration agreement provided it is in writing. So as long as you have provided in writing, then arbitration agreement is recognized under the Act. So meaning that you can arbitrate. Selain tu apa kekuatan dia? So when you have arbitration agreement in your contract, for instance, you have two parties are in disputes, for instance, yeah. One of the party wanted to arbitrate. One of the party wanted to refer the case to the arbitration, and the other party, I would say, is a bit hesitant to arbitrate. So therefore, if one of the parties, the one who hesitant to arbitrate, refer the case to court, for instance, refer the case to court. Yeah? The court, the court can stay off that legal proceeding to give away for arbitration because you have the arbitration agreement. Macam tu. Yeah? Itu kekuatan arbitration. Yeah? And this has been mentioned under the Contract Act 1950. Yeah? The Contract Act 1950 also recognize arbitration agreement. So meaning that kalau kata you ada contractual dispute, dalam contract you ada arbitration agreement, one of the party hesitant to refer the case to arbitration, but the other party wanted to arbitrate, nak refer kepada arbitration, then the one who hesitant to arbitrate refer to the court can stay off that legal proceeding, kena boleh stopkan legal proceeding to give away for the arbitration to the extent. And interim measures by court, this is what I mentioned about the court supporting roles, yeah. Default number of arbitrator. Ini pun antara isu besar jugalah. Kenapa? Why? Because arbitration is not cheap, ladies and gentlemen. Ya. Arbitration is not cheap. Ya. Kalau arbitration tu domestic arbitration, the default number is one arbitrator. Ya. Kalau international arbitration, the default number of arbitrators is 3. Default ni maknanya dia punya standard default number lah. So meaning that you can agree to have international arbitration to have 1. You can also agree on that. You can also agree on domestic arbitration instead of 1 arbitrator, you ada more than 1, you ada 3, boleh juga. Maknanya tapi the disadvantage is in terms of cost lah. If possible, we try to minimize the cost, kan? Sebab appointing arbitrator is not cheap, ladies and gentlemen. Yeah. So therefore, if possible, try to minimize the number of arbitrator. The procedure under Arbitration Act also mentioned about how the appointment of arbitrator supposed to be taken place. Yeah. Contohnya, dia akan pergi pula tengok kepada you punya rules pula, kan? For instance, under the PAM arbitration ataupun under PAM form, under PWD form, the appointment of arbitrator tu ikut macam mana? Under PAM form, the appointment of arbitrator, if the party fail to appoint, the appointment shall be made by the PAM president. So maknanya itu prosedur dia. Yeah. So, but of course, the parties are free to agree on the procedure of the appointment of arbitrator. Tapi kalau you dah agree dalam you punya agreement, the agreement stated clearly that the appointment of arbitrator must be done by the must be done by the PAM president. So, the PAM president should appoint, provided that the parties are not able to agree on the appointment of the arbitrator lah. Ada gitu, yeah. But anyhow, the flexibility is there. The party can agree on the procedure of appointment of arbitrator, yeah. And the ground of challenge for arbitrator, the procedure for challenge, these are the procedure. Ground you nak challenge kalau katakan one of the party disagree with the appointment of arbitrators, atas dasar apa? Appointment due to the qualification ke, yeah, due to potential bias ke. So there are grounds, of course, yeah, there are leeways, there are ways being provided under the Act itself. Okay, all right. The rule of natural justice. Ini antara under section 20. The rule of natural justice means simply that the adjudicator the arbitrator need to give both party opportunity to present their case. Ini antara isu besar lah. Not only in arbitration, also in adjudication juga. Maknanya the parties are given supposed to be given opportunity to present their case. Yeah. The seat and legal anchor. Ini pun antara yang tricky juga ni. Ramai juga yang tanya saya. The seat of arbitration. The seat of arbitration ni maknanya legal anchor. So you have to look at your arbitration clause, ladies and gentlemen. Kalau tak, you are trapped. Yeah, you are trapped. Sebab apa? Kalau tengok kan, the seat of arbitration and the location of arbitration supposed to be in Geneva. So maknanya you have to go to Geneva to arbitrate. You see now? So it incur more cost. Sebab itulah kadang-kadang kita panggil among the arbitration practitioner, sometimes they call it as a midnight arbitration is a midnight clause. Midnight clause maknanya apa? Maknanya you nak finalize your contract tomorrow, malam tu baru you tengok arbitration agreement tu, arbitration clause tu. Maknanya people do not take it seriously on the arbitration agreement tu. So kalau kita tak tahu, kita tak perasan, you are trapped. That's what happened to some of the construction organisation tu. Especially when it comes to international arbitration. International arbitration maknanya one of the parties are from other country. Yeah, from other countries, yeah. So you are trapped by the seat of arbitration. Contohnya we just a normal contractor in Malaysia, yeah, kita punya income pun just okay, boleh survive. Then all of a sudden you are getting counterpart from China, contohnya, yeah, from Hong Kong or from Maldives, contohnya, kan? You nak ada collaboration, to bid a project somewhere in Middle East, contohnya, kan? Then in your agreement dia kata dispute to any dispute between the parties have to be referred to arbitration, where the seat of arbitration in Italy. Habis you, gone. Maknanya apa? So maknanya you are bound by that agreement. You are bound by the so-called predetermined seat of arbitration. So you kata, kita orang normal contractor je doktor. Takkan kita nak pergi ke Italy nak pergi arbitrate? Yes, you are supposed to. Sebab apa? Because that what stated dalam you punya arbitration agreement. Dia gitu. So maknanya what is the way forward? You negotiate lah with the other party. The seat of arbitration supposed to be in Malaysia contohnya. Dia gitu. Jangan dah berlaku dispute baru pasan. Banyak case ya. There are a lot of cases where dah ada dispute baru hantar pada saya print screen. Doktor, boleh tak advice provision ni? Provision ni kata the seat of arbitration in Geneva contohnya kan. So kita tak mampu nak pergi Geneva. Boleh tak kita buat dekat Malaysia? The answer is you can't. Yeah, of course if the other party agree to change, okay lah. Tapi most of the time it is quite difficult. It is impossible. Okay, language. Nah, ini pun antara masalah besar juga in arbitration, because arbitration is inter countries, So that's why one of the critical issue is language. One of the critical issue is language. So of course we have English lah kan as the standard language for arbitration, but not all companies ataupun representative of the company are able to communicate in English, kan. Sometimes you need an arbitrator who are fluent in a certain language. Itu pun antara benda besar sebenarnya. We thought it's something which is something that tak berapa penting, unimportant. Tapi in real arbitration case, language is important, especially when it comes to international participants, different mindset, different culture altogether. So language plays a very important role. Statement of claim and statement of defense. Statement of claim is similar to the process of procedure like in court lah. Claim normally started by the claimant itself ataupun orang yang memulakan proceeding arbitration tu. You have to give your claim, defense and reply. Selalunya 3 tu lah. Claim, defense and reply. So claim, so-called the claimant, then the respondent, and the claimant need to come up with a reply. Itu common lah, standard. I think for adjudication pun sama saja. Arbitration hearing, as compared to the parties can agree on how the hearing is supposed to be taken place. Now buat document only pun boleh juga, tak ada masalah. Okay, so itulah yang among others. And the last but not least, substantive law. Ini pun penting juga, substantive law. Substantive law maknanya undang-undang apa kita nak pakai. You ada dispute, kalau if you look at the case of Tiao Light Night, in the case of international arbitration, seat of arbitration in Bangkok, you nak guna undang-undang apa? So undang-undang pun penting juga, substantive law. You nak guna undang-undang Malaysia ke, Hong Kong ke, undang-undang China ke, undang-undang England ke. So the substantive law pun penting. Kalau that's why you have to negotiate, you have to agree on the arbitration agreement before you finalize your contracts. Kan? Sebab people always thought that Malaysian law and English law is similar. They are wrong. Tidak. Malaysian law is, kita started off from the English law, yes, but we developed becoming our common law system by its own. Maknanya kita punya undang-undang dengan English law berbeza sebenarnya. So be careful. Kalau katakan the substantive law is English law, then you are bound by English law, then you are bound by the UK Arbitration Act. Dia macam tu. That's why ini benda-benda yang you have to take into serious consideration, especially when it comes to the parties which are very much, one of the parties are international counterparts. So kalau domestik, quite straightforward lah, ya, Malaysian law. Ini antara nitty-gritty of arbitration yang ramai orang tak berapa nak take into consideration. Another thing, what happen if we terminate the proceeding? Boleh tak? Boleh, at any time. You can agree on the termination, you can agree on the settlement. The party may agree on the settlement and also terminate the proceeding. Sama juga dengan adjudication pun sama, under SIPA. The award is final and binding. Yeah, you can challenge award, but on a very limited ground. Yeah, on a very limited grounds. Yeah, so you can challenge the award. The law provides so, but not as simple as what we thought. Dia adalah ground kena challenge the arbitration award tu, but it's very limited. Okay, those are the important ones. Then juga last but not least, the enforcement, enforcement of the arbitration award. If you look at in England, for instance, enforcement ni bukan perkara besar sebenarnya, as compared to Malaysia. Malaysia ni kita I don't know, kita nak juga enforce. Kita nak juga kuasakan, kita nak juga perintah mahkamah tu. Basically, it defeat the purpose sebenarnya. It defeat the purpose of ADR itself. ADR ni people go for ADR because people want to resolve out of court. You see, so maknanya there is no need for you to enforce the award in court. Yes, but of course there adalah akta tu adalah that I would say the way for you to enforce it through court. Tapi kalau ikutkan I would say the spirit of ADR is when the adjudicator, the arbitrator, the mediator complete the proceeding, the parties should appreciate and also follow what has been decided. Itu yang sepatutnya. But what happened in Malaysia is other way around. It's the other way around. Kita dah habis arbitration, kita nak kena enforce. Sebab apa? Sebab because the other party, they tak recognize. Especially the losing party lah. That's what happened in adjudication juga. People always say that adjudication is waste of money, waste of time. Why? Because in the end, you're going to court anyway. Kan? Itu people punya thinking, which is supposed to be once the adjudicator, the arbitrator decide, the party should appreciate dan juga follow what has been decided by the arbitrator, adjudicator, and so forth. But of course, the enforcement regime is there. But if you look at the trend of decision made by the court in terms of the enforcement of arbitration, I would say that quite limited ground to refuse the recognition of the enforcement. Quite limited because the court will look at the grounds as what stated dalam akta. Misalnya contohnya macam bias contohnya. Kan kata bias. So how do you substantiate kata okay bias ataupun breach of natural justice. Macam mana you nak? How are you going to substantiate that? It is not easy, ladies and gentlemen. Being a qualified arbitrator myself, kita tahu benda tu. We are aware on the potential of our award to be refused at the end of the day if we fail to uphold the rule of natural justice. So these are the arbitration governing bodies, AIAC ataupun previously called it as KLRCA ataupun RCA-KL. Arbitration Center, it is international. It is considered as international, I would say, agency lah. One of the most established arbitral institution in the region. One of the most established, but not the most established. Kita ada Singapore. Singapore is doing better than us sebenarnya. But I think we are doing well. We are catching up. But I'm not here to speak on behalf of the AIC. Being a panelist adjudicator, I can see that the AIC is doing well in ensuring the quality of the arbitrator and also the rest of the ADR practitioner. Itu on the international arena kita ada CIR ataupun Chartered Institute of Arbitrators. Ya. CIR pun ada dekat Malaysia, so they provide continuous training for arbitration, especially on international arbitration. Especially on international arbitration. So siapa-siapa yang minat nak pergi ke arbitration, nak tahu pasal arbitration, sign up lah. Kalau ada CIR bagi, ada some of the introductory punya courses, ya. You try to enroll if you want to know further detail on that. Tapi CIR ni dia more on UK based lah, ya. Tapi I think I lagi prefer being a Malaysian, we try to understand our own legal system in terms of the arbitration itself. So Malaysia kita ada MIR, Malaysia Institute of Arbitrators, ya. Ini kita punya own Malaysian yang CIR tu international, ya. But anyhow, MIR recognize the qualification of the CIR as well. Ini yang paling latest lah, yang paling baru, ASEAN Institute of Alternative Dispute Resolution. So the previous director of AIC, yeah, Professor Datuk Sundaraju, is the one of the founding member of the AIADR. Yeah. So one of the I would say biggest contributor, one of the biggest contribution lah of AIADR is to promote ADR, especially mediation. Sekarang ni AIADR is try to promote mediation internationally. Ya, so, arbitration orang dah kenal lah. Ya, but mediation ni masih ada lagi a bit of kekangan, a bit of kekangan untuk to enforce the mediation settlement tu. So I think AIADR is doing their I would say their good supporting role for the mediation. These are the soft law, maknanya undang-undang, bukan undang-undang lah, soft law, rules. Dia bukan undang pun, rules saja, ya. Rules yang ada in terms of arbitration procedure itself. Maknanya kita ada arbitration akta, dan itu yang legal, secara legalnya you are bound by the Arbitration Act. Tapi rules ni dia lagi detail, dia lagi detail in term of the nitty-gritty of the procedure of arbitration. Ya. So kalau siapa-siapa nak tahu lebih detail pasal rule ni, boleh lah. Ya. We can you just mention which rule that you want to know. Mungkin kita boleh handle one more workshop on the more detailed procedures, yeah, under the specific arbitration rules. We can do that if you want to. Arbitration procedure, as I mentioned to you, the arbitration clause, the seat of arbitration, the language of arbitration, the governing law. Nampak tak benda-benda yang saya mention tadi tu? Ya, the seat of arbitration, language, ya. Ini benda-benda yang penting yang perlu ada dalam arbitration clause. Because why? Otherwise you are trapped, ya, by that particular agreement. Maknanya you kena baca, you have to understand, and you may able, then you should negotiate. Yeah. As I mentioned, Section 9 on the arbitration agreement. Yeah. Ni pun sama juga. I mentioned earlier on the Section 9. Yeah. Again on the Section 9, this is the procedure. Yeah. Procedure for the arbitration. I ambil daripada Ancestral Arbitration Rules. Yeah. Kita mulakan dengan notice of arbitration, respond to the notice, ya, presentation, appointment of party representative. Kalau you can appoint party representative if you want to. Maknanya the disputed parties may appoint representative. Selalunya kita appoint lawyers lah, ya, ataupun legal counsel. The choice of appointing authority, kan. Then in terms of, you can decide the number of arbitrator, how the appointment of an arbitrator supposed to be taken place. Yeah. Then bila dah appointment tu dah buat, the arbitrator normally kita akan conduct the preliminary meeting lah to clear up of the procedure, to finalize date, bila kita nak kena jumpa, macam mana kita nak buat, it's going to be full hearing ke, document only ke, yeah. Evidences, kita are we being given the opportunity to appoint expert witness ke? So benda-benda tu need to be finalized during the preliminary meetings. type of arbitration, as I mentioned, kita ada domestic arbitration and also international arbitration. Ya, kita ada juga institutional arbitration, macam AIC under the auspices of AIC, under the auspices of Hong Kong International Arbitration Center (HKIAC) ataupun Singapore Institute of Singapore SIAC. Ya. So those are the institutional arbitration. Ya. Ataupun kita boleh buat ad hoc. Ad hoc ni mana sendiri. Maknanya we are not bound by that particular institution. Ya. These are the selected cases on the Damon Lock and Link on as I mentioned, apa nama tu, the parties need to be given the opportunity to present their case. Ya, you tak boleh kata terlalu rigid sangat. Kalau tak, parties rasa dia tak diberi peluang to present their case. Ya. Kalau dia tak beri peluang, maknanya arbitrator akan decide based on what has been available before him lah. Ya. Ini pun sama juga. Dia terlalu nak sangat maintain the apa nama tu okay, dia pasal because the arbitrator normally who are professional in the subject matter, dia nak decide based on dia punya own expertise. Tak boleh lah. Kan arbitrator as the so-called private judge, they have to decide based on what has been submitted by the parties. Yeah. Okay, these are the court cases on arbitration. Ya, maksud arbitration, recognition of arbitration agreement in a governing contract. Party autonomy is the important. What is the party's autonomy? Maknanya, apa nama tu? I recap a bit jadi yang saya kata, the flexibility. Flexibility maknanya apa? The party is given the authority ataupun autonomy to decide on the procedure, how the process supposed to be. Ya. Of course kita ada rules kita. Ya, kita ada rules. Especially kalau katakan you follow, you dah agree to follow HKIC punya rules, then you are bound by that rules. Itu maksud saya. Bukannya kata you agree in term of Caca Merbah punya arbitration rules. Tak boleh. You kena follow. Kalau aku katakan the party agree kena gunakan AIC arbitration rules. So that you are governed by that arbitration rules lah. Yeah. Privacy. Ini antara the strongest point on arbitration is the privacy and confidentiality. Ya, dia tak akan keluar dekat mana-mana berita. Ya. The few other cases. Right. So I nak go straight to the apa nama tu, dispute resolution under form of contract. Under CIDB, this is under CIDB 2000 edition. Ya, kita ada SO dan SO need to decide need to come up with a decision. Kalau tak ada reply, then can refer to mediation dan juga later to arbitration. Ini dalam CIDB lah, 2000 edition. Under PAM 2006, kita ada adjudication dan juga arbitration. So, adjudication ni during construction. Arbitration ni after the practical completion. Begitu. Kenapa? Why is that so? Because the arbitration is more serious. Ya, more serious, more time consuming juga. Kita perlukan you focus on the arbitration. But adjudication ni a bit simpler, yeah. So that's why the adjudication ni normally during construction. Ada yang tanya, ada yang kata adjudication is only for during construction. Tak semestinya, yeah. You can adjudicate after juga. But for arbitration, what Pam also mentioned is after the practical completion. Itu dia punya mantra lah. It is quite consistent with other form of contract as well. Yeah. PAM 2006 ada mediation juga. Mediation will be covered by Surveyor Adi. Ya. Kita ada mediation. Tapi mediation ni cuma optional sahaja. Ya. You can agree on the mediation. Then you can mediate at any time. Tapi arbitration with after the practical completion. Under PAM 2006 and 98, dia kata apa? Either party need to serve. You ada dispute, then you serve the appointment of arbitrator. Within 14 atau 21 days. Kalau you tak boleh agree on the appointment of the arbitrator, then the PAM president will appoint on behalf of the parties. Ya, PWD pun sama. Ya, dia ada within 45 days if fair and party dissatisfied with the decision made by the SO. So maknanya you ada issue, you kena refer kepada SO dulu. Ya, kalau kata SO fail ataupun you are dissatisfied with the decision made by the SO, then within 45 days you are able to refer the case to arbitration. This one under PWD 203 lah. Ya. Ini the procedure lah, within 45 days as I mentioned. PAM also similar to the previous one, itu PAM biasa, dia ada mediation, dia ada juga ada determination. Ini yang latest one. The latest one, dia juga ada expert determination, itu ditambah. Dan juga adjudication. As I mentioned, adjudication only for set off, penolakan kepada you punya payment within the construction stage. After construction stage, then arbitration. Yeah. AIC, dia ada arbitration juga, clause 34. Mediation. Okay, last but not least, okay, I dah sudah bagi ini lah. Last one, the rules of court. Yeah. Ini under order 69 and also order 69A, the court supporting rules on the enforcement of the arbitration award, dan juga order 69A on the set aside of adjudication decision, stay of adjudication decision and enforcement of the adjudication decision. So maknanya dua I would say provision ni give a way for the court to strengthen the ADR, especially arbitration and adjudication. These are my my kitab lah on arbitration. Okay. Okay. So. Right. So that's all. That's all from me. Nanti kita Puan Su akan compile the question. Keep your question until the end of the session, and I'm happy to accept question and also to entertain any question on that. With that, I thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Zul, for enlightening us on the arbitration procedure. Pak, excited, semangat, banyak benda nak share sebenarnya. Alright?
Memang. When I was given 45 minutes, kata, it's quite
tak cukup masa kan? Tak apa. So if you have any question for the speakers, please, as I mentioned, hold it in. You can directly ask them, right, at the end of the session. All right. Now, let us move on to the next session. Okay, alternative dispute resolution, ADR, actually provides confidential, right, and alternative methods in tackling legal disputes, which actually avoids going to court, which we try to avoid, right? So besides arbitration, as mentioned by Dr. Zuhabri, the most common types of ADR are conciliation and mediation, and also adjudication. So with more than 20 years of experience under his belt in the industry, and he is a panelist, mediator, and adjudicator, our next speaker definitely fit the bill on the following topic. So surveyor technologist Adi Shambaharin graduated with a master's in integrated construction project management from UiTM, and he was a graduate of quantity surveying. So he is currently the head of contract administration in the Indah Water Consortium Sdn Bhd, and he is a regular speaker for SIPA Act 2012. That is what I mentioned earlier. He is the right person to talk to you about this, right? So speaking to us on the overview of mediation and adjudication in the construction industry, please join me in welcoming surveyor technologist Adi Shambaharin. All right, so Surveyor Adi, the floor is all yours. We cannot hear you. Yeah. Okay. No, we can't. Boleh check dekat dia punya volume speaker ke? Dekat microphone? Kejap ya. Boleh check dekat microphone tak? Saya rasa ada isu kat situ.
Betul.
Dah. All right, we are facing some technical difficulties. Can you please wait for a while? Right, so we can solve this as soon as possible. So in the meantime, if you have any question, you can use the chat box at the right side of your screen. All right, you can just type in your question. So I'm going to consolidate it and post it to our speaker at the end.
Hello, Su.
All
Dengar
right,
tu?
Alhamdulillah, clear, crystal clear. Right.
Uh, I'm sorry for the technical issues just now.
It's okay, it's okay.
Okay, can I begin, Su? Can I start?
Yes, please.
Okay, Assalamualaikum and very good morning to all the participants and then also the of course the organizer, Center of Studies UiTM. And then I'm here today actually just to share the knowledge, a little knowledge with regard to the mediation and as well as the SIPA Act. So I will share my slide. I prepared some slide for you guys to refer, and I believe that most of the participants or viewers in today's webinar is come from the construction industry. So easy to me to speak in technical language. So okay, I will share my slides shortly. Okay, Su boleh dengar Su? Hello?
Okay, boleh.
Okay, I proceed.
Boleh, silakan.
Okay, Assalamualaikum and very good morning. My name is Elisham Bahrain. So actually I'm the panelist of the education under EIAC as well as the mediator under the Malaysian MMC, Malaysian Mediation Center, which is under the Bar Council. Okay, today I will share a bit on an overview on the what I call it, the mediation as well as the SIPA Act. So I'll be given 45 minutes for both subjects. So I try my level best in order to grab the pertinent points in terms of understanding what is the mediation as well as the SIPA Act. Okay, let's start on the mediation in construction industry. So the definition, you can see the meaning, the literal meaning of the mediation is the informal process whereby the disputants are encouraged to cooperate in good faith to resolve the disputes. And according to the author of the books of mediation, Folberg and Taylor, the define of the mediation is the process by which the participants, together with the assistance of neutral person or persons, which is the mediator, systematically isolates disputed issues in order to develop option, consider alternative, as well as to reach the consensual settlement in the end of the mediation. So kalau kita bercakap pasal mediation is for the on the easy understanding, the mediation is the process whereby both party that have a dispute in the construction or any matters and refer to the mediators for settlement. What is the mediation? The beauty of the mediation, as mentioned by the Dr. Zul, is the voluntary and flexible process. Apa yang kita katakan voluntary because of the both party shall agree to mediate. If one of the parties does not agree on the mediation, is no mediation at all. And of course the flexible because of mediation in nature this very flexible process whereby both parties can agree on the venues, on the days for mediation, as well as the cost for mediation process. And that the other one is informal we call it proceeding in terms of mediation as compared to other ADR. When we refer to adjudication, for example, adjudication more on proceeding, as well as the arbitration per se. So arbitration, they have their own rule of arbitration, and when we compare to the litigation, we need to oblige to the rule of court for the proceeding. But the mediation is more like free and easy, and then of course both parties have a positive spirit in order to achieve the resolution or to resolve any dispute in the construction industry. And of course, again, as mentioned by Dr. Zul, mediation is very confidential. So tak adalah kita dengar any one of the matters being discussed in the mediation will be published in the public. Parties' autonomy is one of the main character of mediation, as well as non-adversarial. It's not like the court. We have a session whereby both parties have a legal rep, and then there will be we call it the cross-examination, question and answer session. But in mediation, it's more like free and easy, informal, and both parties have a right to say and have an equal time and opportunity to raise their case in mediation. So on the process of mediation, I will discuss further in the next slide, so that we can understand what is the process. Because my objective today is to more on the process of mediation. Okay, so various kind of mediation. We have plenty, numerous kind of mediation. You can see as per slide I mean shared here, we have contractual mediation. Actually, contractual mediation is the one that the provision in the contract, construction contract. We have a provision. Likewise, the other platform or avenues. So for contractual mediation is more related to our industry, because looking at the various form of contracts, like PAM form, we have clause 35, if I'm not mistaken, and then we have clause 35 also in the CIDB form of contract, and then we have AIC form of contract, and newly launched by the AIC for the standard form of contracts. But unluckily, under JKR, PWD form of contract, there is no provision for the mediation for the latest version. But I think the last version, I think form 2006 or below, there will be a provision for mediation. Okay, that one is for the contractual mediation. Move forward, MedUp mediation, MedUp, which is a short form for mediation arbitration. This is the combination or hybrid version of mediation, whereby the proceeding will be conducted by the accredited arbitration or mediator, accredited arbitrator or mediator. So the session will begin with the mediation session, and then after a while, of course, by end of the mediation process, there will be issues not being agreed by the parties. So at the same arbitrator will be conduct the arbitration session to settle the remaining disputes. Number 3 is the arbitration mat. So actually, it is a reverse version of the mat up. The arbitration mat is start from the arbitration process, and then of course after a while, after the process of arbitration, the arbitrator feels that a few things or few issues can be mediated. So the arbitrator will instruct the parties to mediate. So that's why we call it the arbitration mediation. So the beauty of mat up and up mat is the cost saving, because you save the time for the proceedings, for both proceedings, as well as the cost saving in terms of the proceeding cost, as well as the arbitration or mediator cost. And of course, we have multiple tier in terms of mediation. We have arbitration, mediation, and again arbitration. This type of mediation was mooted by Singapore Mediation Centre. So this is very super hybrid lah. We can call it super hybrid because the session will be start from the different arbitrator, and then afterward mediation process with the separate mediator, and again go for the arbitration again. And then 3 level of dispute solution in this type of mediation will be conducted on the different arbitrator and mediator. So in order to avoid the conflict of interest. And again, as you know, the impact of the pandemic COVID-19. So anything or any business with the hindrances by the movement control by the government. So people tend to do business online. So again, mediation tak terlepas. So under e-mediation, we have to have a session of mediation online basis through Google Meet, WebEx, and so on and so forth. So the session will be conducted by the mediator through video conference. Co-mediation. Co-mediation is the mediation type of conference that acquire more than one mediator. So maybe because of the complexity of the projects, as well as the huge amount of the dispute, need to have more than one mediator. So that one we call it a co-mediation. Multi-parties mediation is the mediation whereby more than 2 parties involved in the dispute. Normally we have party A and B in the dispute, but in the multi-parties we have 3 parties in disputes at one go, and one mediators to conduct the mediation process. Okay, moving forward, the court-based mediation. Court-based mediation is type of mediation conducted in court. Mooted by the Chief Justice. Chief Justice through the practice direction. There was practice direction number 5 of 2010, and afterward the Chief Justice issued another practice direction number 4 of 2016. The idea to enforce the mediation in the court, because of the bulk of the cases filed in the court is too many. So in order to reduce the unnecessary cases that can be settled out of court, so the Chief Justice mooted the idea of mediation at the pre-trial stage. So before we go to the full trial, So the judge will conduct the mediation session in order to solve the problem prior to the full trial at court. Okay, with regard to this court-based mediation through the statistic issued by the Mahkamah Malaysia, almost 1/3 of the cases registered under the court settled through mediation. It's quite a positive sign in terms of mediation process. We can say that the mediation is the good avenue in order to settle the problem, settle the dispute in the construction industry. Because as mentioned again, as mentioned by Dr. Zul, the arbitration is very costly, and then we can track on the venue of the arbitration and so on and so forth. So in mediation, only the parties involved in the session, the parties can the parties will we call it. It's not necessary the parties to engage the rep for the mediation. Just themselves, then will be okay to go for the mediation session. It's no need a legal counsel or claim consultant, for example, to assist in the mediation. It's very cost effective. And last but not least, the ad hoc mediation. Actually, this ad hoc is more on the matters regarding the community and family disputes. So that's why we call it the ad hoc mediation. Okay. Key highlight on the mediation. What is the pertinent point in order to choose the mediation in one of our dispute solution under the construction contract? So one is the parties have full say over the final result. So in mediation, the parties yang ada masalah or the parties that in dispute, they drive the car, and drive the session in order to achieve the final result. It's not like the arbitration or adjudication, because in other ADR, for example, the adjudication, we have an arbitrator, adjudicator to give the final say or final decision. But in mediation, the parties have a full say for the result. Okay, parties work together to resolve the disputes. In mediation, of course, prior to the mediation, the parties need to have positive thinking, and the way forward to resolve the matters or the issues. Because if not, that's why we have to agree on the mediation. Agree to mediation, then we go for the session. If not, if one of the parties disagree to mediate, there's no point go for mediation. Parties enjoy substantial saving, which is money and time, through mediation. This is very true. Ladies and gentlemen, it's very true. Sebelum kita decide go for the other ADR, arbitration, adjudication, or even settle in court, we mediate first, because you can save a lot of money and time. Because, for instance, for the mediation, we just incurred costs in terms of paying the fees for mediators only. But when we look up on the adjudication and the arbitration, so the money or the cost for proceeding is very costly. We need to pay the legal counsel, we need to pay the arbitrator or the adjudicator, as well as we need to engage a claim consultant to prepare our claim, and so on and so forth. So mediation is very simple and give you a saving in terms of money and time as well. So kalau kita tengok on the adjudication, the process will the endurance for the process will exhaust you, because education will took you 4 to 5 months to settle, to receive the education decision issued by the adjudicator. But through mediation, the session will be the most, based on my previous experience, we settle the mediation in 2 days, 2 days only, then settle, as compared to other ADR. And then because the time relates to money, so shorter time, so we can save more money. Of course, mediation is informal, as I mentioned earlier. It's informal session. We not abide to follow certain rules or procedure, so we just go along with the process, and of course, mediator will chair the process, and we navigate the parties in order to achieve the settlement. And of course, prior to the settlement, the mediator, through he or she skill, build up the option to settle, and then try to convince the party for various options available on the table. Then the end of the session will be a settlement agreement that will be signed by both parties. It is confidential, of course. Whatever discussed in the session, whatever agreement in the session will be keep confidential, and will be not published to the publics. Mediation is parties free to opt under ADR in the event mediation is not successful, of course. For other ADR as well, there is the provision that allow the parties to terminate the session and go for other option. So, for example, like mediation, one of my previous mediation cases, whereby the parties is agree to disagree. So agree to disagree. So meaning that the mediation is not successful. It's not successful, but they agree to go for the next level, go for the litigation, for example. Alright, dalam mediation there will be the institute to oversee or to conduct the mediation proceedings. They have a procedure and rules under certain agencies. So in Malaysia, we have, of course, Asian International Arbitration Centre, AIAC, and then we have Malaysian Mediation Centre, which is under Bar Council of Malaysia. We have CIDB, we have Pertubuhan Arkitek Malaysia, PAM, as well as Malaysia Master Builders Association Malaysia. These 5 agencies is very dominant agencies atau institute in order to giving the services in terms of mediation. So I think most of the active institution is the AIC and MMC in Malaysia, whereby most of the cases or dispute referring to these 2 organizations in order to start the mediation. Alright. Moving forward, we look on Mediation Act 2012. Mediation Act, we have an act per se exclusively for the mediation process, whereby the Parliament have passed the draft bill, and then afterward enforcement of Mediation Act 2012. So the key highlight on the act, I cannot go into depth in the act because our session today is more on the process of mediation itself. So for the understanding on the act, so I just highlight on the parts in the act that ada lebih kurang 7 parts in the acts. We have part 1, which is preliminaries. We have part 2, commencement of mediation, and then afterward we have mediators. We have a mediation process. We have conclusion of mediation, confidentiality and privilege, and of course we have the last part. Part 7 is miscellaneous, which is discussing and overlay the cost of proceedings. Right. Okay. Like I mentioned earlier in this session, there is a provision in the construction contract with regard to the mediation. We have PEM contract under clause 35, and of course we have EIAC contract clause 35 unconditionally under clause EIAC. So the parties in dispute may go for the mediation unconditionally. So the party will freely go for the mediation without condition. So under CIDP, the line sikit because under clause 47(2), so the parties need or shall mediate prior to arbitration. So dalam CIDP dia conditional, bersifat conditional, whereby the parties kena mediate dulu sebelum go for the arbitration. But compared to the EIAC form of contract, is very different because the parties can go concurrently in terms of ADR. You can mediate at the same time you go for arbitration. Okay. But luckily PWD tak ada lah. PWD tak ada. PWD kontrak hanya ada arbitration clause. Arbitration clause. But last time we have the provision for the mediation, but the latest form contract PWD 2010 tak ada lah. Tak ada, the provision is not been there for some reason. Okay. I am more excited to present on the mediation process lah, because as a stakeholder in the construction industry, we need to have a basic knowledge in terms of what is mediation all about. So I'm more on focusing on the process of mediation. So prior to the mediation, the parties, depending on the construction contracts, the parties that intend to go for the mediation will serve the notice to other parties for mediation. So, and then the other party within certain date need to reply for agreement. So after the agreement to mediate, so the parties need to appoint the mediator. So kalau through Bar Council or MMC, the party may go for the MMC for case registration, and of course the MMC will ask the party if there anyone you need to appoint, you agree to appoint. Kalau tak ada, so the MMC itself will appoint the mediator for the parties. So kalau dia dah appoint tu, you tak boleh nak tolak lah, because the appointing parties authority is on the MMC hand in the absence of agreement by both party for mediator's appointment. So kalau kemudian apabila mediator have been appointed and agreed in term of agreement, the fees and been agreed by both party, so mediator will the MMC will officially lantik lah, melantik the mediator, Mr. X for example, for this subject matter or dispute matters. Okay, bila mediator dah appoint, so the mediator will conduct what we call it the pre-mediation. So pre-mediation meeting ni actually the normal meeting. So the mediator will invite both party for a meeting to actually to explore the issues prior to the mediation yang betul-betul yang betul-betul lah, mediation conference. So the mediator need to have a idea with regard to the disputes, as well as to set the ground rules dalam mediation. Walaupun mediation is informal, tapi ada ground rules need to be obliged by both party in order to make the process smooth. And then of course the mediator will conduct the mediation process in a good manner without any hindrances or any difficulties. So the mediator will lay down the ground rules for the mediation, and then it's very important to mediator to establish the dates, time and venue for mediation conference. So both party need to agree on the venue and the dates of mediation, as well as the time, because dalam mediation is very important to have a person or individual that can give the authority to settle dalam mediation dalam mediation conference. Because kalau kita go for the mediation conference, kita hantar our staff ataupun the person which does not have an authority to settle, so it's no point go for mediation. Sebab mediation will conducted, and of course after a while through the process, the mediator will ask for authority that the person can give the commit for the settlement. Itu penting lah dalam mediation. So kita tak boleh lah bila mana kita agree to mediate, kita hantar our staff for presenting the company for the mediation session. Okay, bila mana pre-mediation dah settle, so all the time, venue dah tahu, so maybe some document to be submitted to the mediators for further details and understanding of the issues. Bila semua dah settle, and then we go for the actual mediation conference. We call it mediation conference lah. So dalam mediation conference tu, they will be given the time, the time, agreed time and venue lah kan. So bila kita dah pergi ke dalam mediation conference, so the session will be start by the opening remarks, opening remark by the mediators. So dalam mukadimah lah, mukadimah dalam session mediation conference. So the mediator will start with the opening statement. So mediator akan cakap this is akan introduce diri dia, and then of course dia akan minta both party introduce themselves, and then what is the objective of the mediation, and so the mediator need to explain to reiterate the processes, the rules of the ground rules of mediation process, and of course some do and don'ts in mediation. Selalunya dalam mediation there will be one speaker at a time, so tak boleh cakap serentak lah, so mediator tak boleh nak capture the issues. So itu adalah salah satu rules yang penting lah dalam mediation. Tak boleh on telefon you switch off, and of course tak ada bad words in mediation. Tak boleh kita cakap yang kasar lah. So bila mana kita cakap kasar dalam mediation will provoke the other parties to hijack you lah. So itu antara rules yang don'ts lah dalam mediation conference. So bila mana dah settle mediator's opening statement, so we go for the next step, whereby the mediator will invite either party to start with the discussion. So the parties free to start first lah. Siapa yang nak start dulu, we can start. So the party will raise the issues and we discuss the matters, whatever dispute by one party to the other parties lah. So first joint discussion ni more or less on the raising the issues, and of course to let the other parties know what is the essence of the problem or the issue, the matters, the subject matters, and of course for the further understanding of the mediator. So dalam first joint discussion ni, so the mediator will ask the parties to raise the issues. So the other party can opt to go for macam slide presentation ke pun boleh kan. So yang penting both party have an ample and equal time to present or to raise their case. Itu yang paling penting lah. So dua-dua belah pihak have ample time to raise the case. So kemudian by end of the first joint discussion ni, so the mediator will capture the gist of the matters lah. Maksudnya kalau mungkin ada benda-benda yang tak penting dalam issues yang terbabit, but through the skill of mediator itself, they can pick and choose the main issues, to mediate ataupun to discuss further. So bila mana proses tu dinamakan setting the agenda by the mediator. So mediator akan selalunya dalam session there will be a whiteboard lah di belakang mediator, so the mediator can write properly the subject matter lah, the issue lah. VO number 1 for example, VO number 2, EOT, and then of course we have other contractual matters likewise, macam ada subject that need to be addressed kan, macam safety issues in construction site and whatnot lah. So bila mana setting agenda telah berlaku, so the mediator will discuss one by one. So the other unnecessary matters or issues will be deleted lah. So we focusing on the main subject. Sebab sometimes people tend to raise anything in the back. Semua dia nak raise kan. Tapi in reality only one or two sahaja subject matter yang penting in order to settle dalam mediation kan. So itu terpulang pada skill mediator tu sendiri, and then and background mediator tu sendiri in order to capture the important points in the dispute kan. So selalunya perbincangan akan hangat lah dalam first joint discussion, because both party will change the argument, will change the idea, will change the allegation by one party to other party and the other party to another party. So macam quite a hot session lah. So bila mana dah the mediator kena pandai lah. So bila mana dah hot and then the temperature pun dah rising by both parties, so the time to stop for a rest. So bila mana mediator merasakan that session need to be stopped, so the mediator will invite either party to go for private caucus ataupun private discussion. Itu adalah dalam step 3 ada my slide lah. You can see the step 3 private caucus ataupun private meeting. So private meeting ni maksudnya the mediator will invite that either party to have a discussion alone with the mediator. So maybe dalam first joint discussion tadi mungkin ada some of the issues ataupun some of the facts or allegation or something that not suitable or appropriate to be exposed in the joint discussion will be discussed in private caucus. So the party uh, yang merasakan ada benda ataupun ada isu yang kena address dalam private caucus ataupun ada benda yang need to be shared with the mediator alone, that will be the suitable platform lah dalam private caucus tu nanti. So okay, bila mana private caucus tu berlaku, so that their party will be go off, dia akan keluar bilik, and then of course there will be apa orang cakap, ada refreshment kat luar apa semua. Itu sebab venue tu sangat penting lah, so venue kena tempat yang very neutral kan. Macam contoh kita buat kat resort kan, buat kat resort yang luar, yang suburb sikit kan, so suasana dia tenang, the environment is very healthy in order to settle. Kalau kita buat kat office di KL for example, so dengan bunyi traffic kat luar, and then people keluar lalu lalang dalam di luar bilik meeting, so that factor can influence the mood of the parties in order to achieve, and that's why dalam mediation ni I advise the party to go for neutral parties, neutral place, neutral venue. So macam dekat the outskirts sikit lah kan, we go for dekat beach ke kan, so the hotel yang ada yang provide the meeting punya bilik, so that is very suitable places to conduct the mediation. Okay, bila mana ada parties dekat luar, one parties have a discussion with the mediator, so the party will reveal everything lah kan. And private caucus ni sangat-sangat penting lah kan, in order to mediator to try to build up the option to settle. But sometimes the parties can't see the possible settlement option in order to come to the agreement lah. So sangat penting lah private caucus ni. So bila mana dah ada party dah settle, so the mediator will invite the other party yang dekat luar tu come to the room for the private caucus lah, for the second party. Macam tu lah dia berlaku kan. So bila mana dua-dua belah pihak dah reveal everything, dah put on the table dan have created the option, 1, 2, 3 option for the other party to consider. So and of course yang penting, so dalam private caucus ni the mediator akan bersifat neutral of course, and bersifat neutral dan nampak neutral. Dia kena nampak neutral. Kalau tak nampak neutral, takut dia ada parti cakap ada unsur-unsur impartial kan, dia berat sebelah. Itu kita the mediator try to avoid that particular dia punya dilemma kan. So mediator try to be neutral as possible in order to gain the trust from the parties and build up the option. So private caucus still confidential, so the other party may not have a knowledge of whatever discussed in the private caucus lah, unless the parties allow the mediator to reveal to other parties. Itu lain. Kemudian mediation will move on the second joint discussion. Kalau second joint discussion ni adalah the session whereby the parties will discuss again the matters, discuss again and table up the option yang telah dibuat dalam private caucus tadi lah. So the party will be heard the option by both parties in order to achieve the agreement. So let's say for example agreement tu berlaku kan, persetujuan telah berlaku by both party to settle the issues, then we go for the final stage, the agreement, settlement, the process of mediation terminated by means of agreement lah. So bila mana kedua-dua belah pihak, both party agreed on certain agreement, so that agreement or verbal agreement need to translated into the written agreement lah. So kalau the parties have and ada lawyers for drafting the agreement, they will be good and the drafting the agreement which is consists of the item that agreed during the mediation, just put in. So both party need to sign that agreement and authenticate by the mediators in order to make the agreement enforceable lah. So makna kata lain, the agreement or agreement mediation ni akan adalah satu dokumen can be binded lah because both party dah agree. So all the condition, all the agreement that agreed during the mediation will be put in writing, and both parties sign and again authenticate by the mediators untuk sahkan lah. So itu adalah kurang lebih the mediation process, normal mediation process. So kadang-kadang some of the cases tu nampak macam besar, tapi when come to the mediation yang can be settled, half a day pun ada, 2 jam pun pernah berlaku, 2 jam dah settle bila mana both party have a positive spirit to settle the issues through mediation, so they will be good. Kalau cepat settle, the both party can enjoy the cost saving and time lah. Okay, that's all about the mediation process. Okay, mediate don't litigate lah. Okay, Su, Puan Su.
Ya, saya.
Okay, that is my first topic lah. I move on the second topic.
Yes, please.
Okay, alright. Thank you. Okay, before I forget, I think as mentioned by the moderator, you can post your question in the chat box lah when the session berjalan lah. Feel free to do that. Okay, SIPA 2012. SIPA 2012, which is short form from Construction Industry Payment and Adjudication Act 2012. A bit introductory or overview of SIPA Act 2012 lah. The purpose of SIPA. Apa sebenarnya SIPA? Actually, the SIPA is an act to facilitate regular and timely payment, to provide mechanism for speedy dispute resolution through adjudication, to provide remedies for recovery of payment in construction industry, and to provide for connected and incidental matters. So the key word in the purpose of SIPA is regular and timely payment, to provide mechanism, and of course to have remedies to recovery the payment. Okay. Sedikit background on the birth of SIPA. SIPA telah lulus di Parlimen pada Mac 2012 dan kemudian dapat perkenan agung pada 18 Jun 2012 dan come into operation only 15 April 2014. So pass di Parlimen 2012 dan enforceable on 15 April 2014 onward lah sampai ke hari ini. So kurang lebih lah 6 tahun lah umur SIPA lah. So for information, through the statistic issued by the AIEC as a governing body for the adjudication, memang year by year the number of cases is rapidly increase year by year. So meaning to say that the SIPA is jadi popular lah, popular, one of the ADR yang popular amongst the ADR as compared to mediation and arbitration lah. So SIPA, tapi of course SIPA limited to certain areas lah. The more on the payment dispute. Kalau ada contractual dispute, so the parties need to have another ADR punya avenues like mediation or arbitration. Okay, dalam Act SIPA ada lebih kurang 6 bahagian lah, 6 bahagian penting. So part 1 preliminaries, we have part 2 adjudication of payment dispute, we have adjudicator, enforcement of adjudication decision, we have adjudication authority, we have general, and last but not least the part 7 miscellaneous. So tuan-tuan boleh Google SIPA Act ni, SIPA Act dalam ataupun pergi ke kita boleh pergi ke website AIC lah, AIC, www.aic.com, so we can download for free on the Acts. So advisable lah to the construction player to have this book lah. This booklet was issued by the AIC, free. So free to visit the AIC punya bangunan di Bangunan Sulaiman, di opposite di Kuala Lumpur, sebelah KTM Malaysia, ataupun opposite opposite Majestic Hotel kalau tak silap. Okay, that is the acts. So I have 10 minutes. I need to speed up a bit for the section. Okay, regulation 2014, actually this is the document that complement to the acts, but act itu is the body of the act. So the regulation is complement, the more detail. Sebab not all in the act explain everything. So in order to further understand in term of SIPA, we need to read also the regulation 2014 as well adjudication rules and procedures. Ini penting in order to us to further understanding in term proceeding rules and procedure. Okay, just a diagram for the adjudication process. So proses ni bersifat prosedural. SIPA ni bersifat prosedural, bersifat prosedur yang mana dalam SIPA there was the procedure set by the act to be obliged by the parties. Kalau tidak, dia akan jadi tak sah lah. So tak sah because of the act dah lay down the procedures and the regulation. So normally when the things crystallize, dalam SIPA we talking about the payment disputes. So payment dispute tu dah berlaku, dah crystallize. So the claimant ataupun the unpaid party, orang yang tak dibayar ni, kena serve the notice to the other party, to the non-paying party under section 5 payment claim. Kemudian within 10 working days, bila mana orang yang tak bayar tu telah terima payment claim, dia boleh respond. Under section 6 SIPA Act, there will be the payment response. Dia boleh respond lah. Dia boleh pilih sama ada respon ataupun tidak respon lah. So kalau dia diam, maknanya diam tanda, bukan diam tanda setuju, diam tanda dia totally dispute the whole payment claim lah. So bila mana non-paying unpaid party tu tak terima apa-apa khabar, after 10 working days, dia akan start serving the notice of adjudication under section 7 and 8 of the SIPA Act. So dia akan serve the notice to the unpaid to the non-paying party, cakap the matter will be go for adjudication, and afterward, after 10 working days, the unpaid party kena register the case to AIC plus request the director of AIC to appoint the adjudicator. So adjudicator bila dah dilantik, adjudicator akan keluarkan direction untuk the claimant atau penuntut submit the adjudication claim under section 9. Kemudian bila dalam masa 10 hari so dalam masa 10 hari ataupun dalam masa 10 hari juga bila mana the respondent receive the adjudicated response, so the respondent kena issue adjudication response lah kan under section 10. Kemudian bila mana claimant receive the adjudication response from the respondent, so the claimant need to have ataupun need to issue the adjudication reply under section 11 of the Acts. And of course after jangka masa for the claimant to prepare and submit the adjudication reply is only 5 days as compared to their previous notices whereby only 10 days given, 10 working days given for the parties to respond. Kemudian after adjudication reply section 11, 45 days, within 45 days, working days, the adjudicator shall issue the adjudication decision under section 12. So kurang lebih the whole process really took us about 4 to 5 months for the proceeding to be finished. Okay, key highlight on the SIPA, the application of SIPA. SIPA applicable to all construction contract in writing, made in writing in Malaysia ataupun partly in Malaysia. Dan under section 3 pula describe on the non-application whereby the contract in writing by natural person for building less than 4 stories and fully intended for his own occupation, itu tak boleh lah Kalau tuan-tuan ataupun puan-puan ada projek, let's say for example tuan-tuan adalah contractor for construction of bungalow for Mr. X, so dia tak bayar dan tuan-tuan tak bolehlah bawa non-payment issues ini ke SIPA because dia dah the nature of the project is fulfill the requirement under section 3 ni lah. So kalau bangunan tu less than 4 story dan juga projek tu untuk kegunaan sendiri, then tak boleh go for the SIPA. But different on the residential projects. Residential project is commercial projects walaupun dia less than 4 story ataupun dia tu dibuat rumah kan untuk kegunaan jualan, itu perkara lain lah. So meaning boleh brought to the SIPA for adjudication. Enforceable in High Court as summary judgment under section 28. Of course, macam Dr. Zul cakap tadi, the ADR itself actually kita nak avoid the involvement of the courts kan. So that's why we will have ADR. But as a Malaysian, semua nak tengok juga surat mahkamah kan. So adjudicator ni sometimes adjudication decisions tak laku kan. So SIPA did provide the provision for enforcement in High Court as summary judgment. Senang lah. So kalau kita dah menang, we just go for the application of OS, Urgent Summons, untuk apply for summary judgment di High Court tanpa melalui full trial. Kita tak ada trial lah. We just apply application of summary judgment for enforcement of adjudication decision under clause 28. Kemudian suspension or reduction rate progress of performance as 29. Begitu juga itu adalah SIPA punya provision for remedies. Remedies kalau kita menang dan still dah ada parti bayar juga, so we need to have the remedies under the act. So kita boleh opt for suspension or reduction of rate of works. Okay, moving forward, we have direct payment from principal section 30 in the event that the other party yang menang tu dia tak berjaya dapat duit, so they can go for principal of the project to get to set off the payment lah, ataupun dapatkan payment direct from the principal lah. And then section 31 we have concurrent exercise. So maksudnya SIPA boleh proceed, arbitration pun boleh proceed lah accordingly. There's no restriction because SIPA dia bersifat concurrent lah. So under section 35 ini adalah paling penting sekali tuan-tuan dan puan-puan, prohibition of conditional payment. Ini adalah the action of the SIPA ataupun dia punya taring lah SIPA ni prohibition of conditional payment, ataupun kalau kita cakap pay when paid. So kalau tuan-tuan dan puan-puan have a contract in writing which provide the pay when paid provision, so under SIPA Act dia akan overrule. And of course we have section 36 default provision. Kalau dalam our construction contract does not have any provision for term of payment, dalam SIPA ada, dia dah sediakan default provision 30 hari lah. And we have a cost dalam SIPA ada cost, we have a representative cost, we have AIC fee as well as adjudicator fee. Kemudian SIPA, the beauty of SIPA is apply the doctrine of cost to follow the event lah. Siapa yang kalah dia akan tanggung cost. So whatever cost incurred by the winning parties will be borne by the losing parties lah. And again, pay when paid clause 35, we have SIPA perspective in nature, not retrospect. Ini telah diselesai soalan, question of law telah diselesai di mahkamah baru-baru ni. So meaning say any construction contract signed before the enforcement of the SIPA tak boleh bawa ke SIPA lah kan. So any construction contract signed after 15 April 2014 boleh go for SIPA. Okay, short time frame for SIPA 4 to 5 months, cost effective compared to arbitration cost. SIPA is mandatory unless exemption order section 40 mandatory dia bersifat statutory dia bersifat SIPA tak boleh di contract out lah. So kalau tuan-tuan dan puan-puan nak letak new provision under your construction contract, SIPA is not, for example, SIPA is not applicable in this contract, tak boleh lah. SIPA bersifat ni lah, subjektif. Dia bersifat public policy lah. So nak tak nak kena SIPA lah, tak boleh lah. That's all from me. Terima kasih banyak-banyak kepada organizer again, Puan Su, and the Center of Study UiTM. So again, my name is Eddie Sham. Feel free to email me if there are any question on the email as stated in my slides. And of course, I love to share my slide if there are any ada requirement from the participant. And that's all from me. Back to you, Puan Suhana. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Surveyor Eddie. Again, it's a very lengthy topic. 45 minutes is not enough.
Tak cukup.
Tak cukup. All right. However, we are going to have another session, inshallah, in November. So we are going to talk in length about SIPA. We're going to talk in length about arbitration and whatnot. All right. So again, thank you for addressing those very exciting topics and enlighten us on the mediation and adjudication process, especially in relations to construction industry. So now we are going to open the session, the discussion portion of the session. So it's a live question and answer session. So in a few minutes, you will have an opportunity to speak directly to our speakers. So you can unmute your microphone if you want to, and you can ask the question directly. So I would like to emphasize here, make sure that all question that is going to be posed should be professional in nature and in a form of a question. So in fairness to the speakers and also other attendees, try to limit one question per person. So please state your name and affiliation before posing your question. And we also open the session for question either in English or in Bahasa Malaysia. So it's actually a knowledge sharing session. So please don't be burdened by trying to converse properly or whatnot. It's just a very simple, very relaxed kind of setting. And I can see that there's a couple of questions, all right? And Dr. Zul actually already answered it, but right. So if others have any other question, you can just directly unmute your mic and just share your question. Right? Anyone?
Can I ask one?
Yes, please.
Nasim sini.
Uh-huh.
The question is the panelists' views on oral contracts, because at the moment, if you look at other countries, in fact, most of them cover under their adjudication equivalent acts oral and written contracts. Only Malaysia and I think Singapore only caters for written contracts. Whereas we know in the industry, there are many, many subcontracts which are done orally. So they're not captured under SIPA. So they have to go to court. That's the only remedy. And there's no arbitration clause as well. So I want to have the views of both the panelists on the future, if we can amend the act, whether we should suggest that maybe oral contracts should be included within SIPA.
All right. Thank you, Mr. Nasim. All right. So I open the question to both our speakers. Dr. Zul, you may start.
Okay, thank you, Mr. Nashad Ali Nasim. It's a very good question, basically. I didn't know that you were there. All right. So basically, when we talk about oral contract, it's a very interesting question. Yeah, I do agree with Nasim where the oral contract is one of the critical issues. But having said that, as you know, arbitration adjudication does not recognize verbal ataupun oral contracts. And furthermore, the Evidence Act does not applicable to arbitration and adjudications. So by virtue of the Evidence Act does not being accepted, being applied in arbitration and also adjudication, automatically the oral contract, the parole evidence rules does not comply. And the parole evidence rule does not comply. So which is mean that it is, I think in order for us to establish that the oral contract is acceptable, we need to change the act to integrate the parole evidence rule, to integrate the Evidence Act. So therefore, the oral contract can be accepted. So if that is the way forward, if we would like to recognize the oral contracts, and having said that, that is one of the I would say the loopholes. And I do looking at the current, I would say. The current trend in terms of the recognition of the written contract. Looking at the background of the arbitrator adjudicator, I think the training need to be provided to them as well, because when we talk about parole evidence rules, it is quite I would say it's not that straightforward. Yeah, looking at the background of the arbitrator adjudicator, many of the arbitrator adjudicators are not having a sound legal knowledge. Mm-hmm. So they have some basic knowledge in law, but to cater for that, we need to have adjudicator, or arbitrator. Those who are not legally qualified need to attend training for that particular part of the law itself. And to answer your question, yes, I do agree with you, but we need to do more to equip our arbitrator and adjudicator to tackle a question on the parole evidence rule, which is part of the Evidence Act, and the Evidence Act need to be recognized by the Arbitration Act and as well as the adjudication, SIPA. Thank you, Nasim. I think many are not aware that Nasim is one of the one who actually drafted the earlier provision of SIPA. So I have the opportunity to be with him. During the initial. I would say the initial development of drafted the SIPA. So I think Prof. Nasim as well as the current Constitutional Court judge, which is Dato' Chong Fong. Those are the pioneer, I would say, the pioneer on SIPA basically. So these are the one. So when I saw Nasim in the list of the attendees, I was so nervous basically. I didn't know. I suppose to inform the administrator not to accept Nasim to be part of this. Okay, I think I'm answering your question, Prof. Yeah.
All right. Survey, I think, what's your take on this?
Okay, just a short one on the idea of the oral contracts. I do disagree on the oral contract to be inserted in the current SIPA because of one is the moving forward to the established concession contracts in order to raise our benchmarking in terms of professionalism in terms of the construction players and the construction stakeholders. So written contract is, to me, is important, is very essential, is vital in order to educate the upcoming players come into joining us in the construction industry. So the oral may be settled in court, and then of course with oral contract deviated the true meaning or true objective of the SIPA, because when talk about the evidence, we talk about the hearing. We need to have the hearing, of course, in the adjudication, because as we know, the adjudication itself is the quick process, rough justice or not and whatnot. So that is my opinion in terms of oral contracts. Prof. Nasim. Watai, thank you.
Yeah, just to add on a few more words. Basically, looking at the trend where I think if you're aware with the latest court judgment, I think the High Court of Johor, mentioned that if the party requested for oral proceedings, then the adjudicator need to accept it as part of the natural justice. So having said that, what of purpose of having oral hearing if we cannot accept the oral accept the oral ataupun the contract in the oral contracts? So I think that's one of the things. Then and furthermore, looking at the number of days, the 45 working days for the adjudicator to decide decision, I think it's quite fair enough as compared to other countries. I think from Nasim aware that in other countries, in UK or in the other counterpart, the number of days for the adjudicator to decide is much more shorter. So having said that, we might be able to cater for oral contract as part of the construction contract, because as you know, the common law recognize oral contract as well. So any words from you, Prof. Nasim?
Perhaps I'll respond to Adi Syam's comments tadi. Fair enough. Memang betul lah. It's better to have written contracts, agreed. I mean, for Muslims, even the Quran says when you have transactions, put it in writing and so on. So excellent point. So that means what we need to do is the industry needs to persuade everyone to write in, to reduce their contracts to writing lah. That's one. The problem is when the contract is not in English, nobody understands. So elok kita buat contract in plain English lah. So there is already a contract published in Malaysia, the first construction contract in the world to get the plain clear English accreditation from the Plain Language Commission. It's available freely published by CIDB, endorsed by industry. So we should encourage everyone, no matter how small a project, to use it, because then that will be captured under SIPA. That's the comment I have to Adi Syam. And then to Prof. Madya Zul, it'll be good to have contracts included in oral contracts. The main reason being, we're missing out, like kesian, all those many subcontracts. I know we can persuade them to enter into written contracts, but still there are many oral contracts which are not picked up, meaning their only recourse is to go to court. Arbitration tak ada. So sayang. It's a missed. The industry is not serving justice to them. Also, if we look at around the world, out of the 14 or so jurisdictions, even UK dulu oral saja. Written saja. Sekarang dah masuk oral. So all the countries dah masuk. They are able to cope, as you said, Prof, you need to enhance the quality of adjudicators. Then it will be fun. But yeah, so both lah. I agree with both of you.
All right, thank you, Prof. Okay, so let's continue. There's a couple of questions in the chat box. So this question is from Encik Ahmad Arzli, and he directed the question to Dr. Zul. Do you mind sharing a bit on expert determination, which he believes that it is not particularly new, but it is not commercially familiar in the construction industry? Right, Dr. Zul, your take on that?
Yeah. I do agree with Encik Azli. Basically, expert determination has been around for ever since, basically. But it does not being recognized as a method by its own lah. I think it's a matter of time for any agency. I think ISM is trying to push for the expert determination to be one of the ADR as well. So maknanya it is being around for quite some time, but it has not been recognized. Dia tak diletakkan di tempat yang sepatutnya lah. I think I do agree with Encik Azli on that lah. And also Mr. Wong also mentioned about as regard to the standard form contract for payment mechanism, is that mean that there is no provision or the provision are adequate for payment default under? Okay, dia gini, for SIPA, if the payment provision is not clear, kan, it's not detailed enough, it's not clear, then the SIPA payment terms, the default payment terms will be included as the implied, one of the implied provision lah, I would say. So therefore, if your contract is clear enough in terms of the payment provision, so then that payment provision is supposed to be uphold lah. Yeah. The SIPA only provide the default payment provision in the event of if the payment term is not clear enough. Yeah.
All right. Survey Eddie, you can add on that, on the question that we have standard form contract provisions for payment mechanism. Is there? It means that there's no provisions, or the provisions are in it.
I agree on the Prof. Dr. Zul, on the provision under section 35, if I'm not mistaken, or section 36 under SIPA, which provide the what you call it, the remedy lah, so-called remedy to in the absence of provision under the construction contracts. So we have 1 month, for example, 1 month duration for the time for the monthly payment, as well as the referring to the method of valuation of payment and variation, and so on and so forth. Thank you.
All right, thank you.
So coming back to the Mr. Wong question, yes, if there, even though there is no payment term, the dispute can be referred to, as long as you fulfill the section 3 and also section 2 of the section 2 and 3 of the SIPA, then you are able to bring the case to SIPA.
All right. Okay, we have another question here by Mr. Chifui. Is the adjudicator obliged to adjudicate all matters dispute brought before him? For example, I can provide an example here. If the respondent files his defense against a payment claim by inserting LAD claims, then it is the adjudicator required to decide whether the LAD imposed under the contract is valid before taking the LAD into consideration. All right. So basically, the question here is, does the adjudicator oblige to adjudicate all matters? Is there any limitation or prohibits any types of disputes that is going to be resolved through arbitration, in this case, adjudication? Right? I think Surveyor Eddie can answer on this.
Yeah. I think the LAD portion in terms of construction contract is actually the work done. The omission of the work done because of the delays. So in terms of SIPA, I believe so. You can go for the SIPA for claiming your work done, which been set aside or deducted by the LAD imposed by the other party. In the case that the matters or the LAD is wrongfully imposed by the employer or client to the contractors. So yes, you can go for SIPA, in my opinion. Thank you.
All right, thank you. Another question here by Encik Muhammad Sufian. Can we consider WhatsApp chat as an oral contract?
So can I attend to Ms. Chief for a question on
Yeah,
the
sure.
So basically, there are few I would say ways of interpreting the act or to interpret the statute. It's one of it based on the what we call it as purposive interpretation. Yeah. So the purposive interpretation of the SIPA is meant for payment. It's a payment acta, act related to payment. So the letters. So if the issue is about payment, so and LAD is part of it. So therefore, the adjudicator has I would say, the jurisdiction to decide the issues. So meaning that if you have LAD counterclaim by the other party, then of course the adjudicator has the authority or the jurisdiction to decide. Yeah, they are quite established. I mean, it's quite the law is quite clear on this. Yeah, there are cases that actually confirm that when there is any counterclaim, in the event of LAD, yes, the adjudicator has the jurisdiction to determine whether the LAD is imposition of LAD is
Valid or not?
valid. Yeah, that's right.
Thank you. Yes, the question from Encik Muhammad Sufian. Can we consider WhatsApp chat as an oral contract? Because nowadays people are, communication is through WhatsApp, so everything is there. So is it considered as an oral contract? Right? Anyone can start?
Dr. Zul.
So basically, it's a bit tricky. Basically,
Yeah.
It's a bit tricky question. I think the law has not been finalized on this, but basically to me so far, because WhatsApp chat is, if you look at if you read purposively, WhatsApp chat is considered as informal means of communication. So
Yes.
under that particular ambit, so it may not be recognized as a written. Yeah, I think that's one. But of course, until the court decide otherwise, I think that's my take on that lah. Yeah.
All right. Survey ID, do you like to add on that?
Yeah, I agree on the Dr. Zul interpretation in terms of WhatsApp, because based on the current or previous cases that decide on there is no such cases that referring to the WhatsApp the authentication in terms of the contracts existence. But again, if there any transition through WhatsApp by document, for example, the other party submit or serve the notice through document via WhatsApp. So we look into the document that transfer from the one party to another party.
That's
then
right.
will be the contracts. The
Not
written
the
contracts.
chat, not the chat itself, right?
Not the chat.
Not the chat by
Yes.
by itself.
Yeah.
I think I'm quite interested to know to discuss further question by Surveyor Nas Rahim. I think I could imagine the complexity on dealing with adjudicated decision if evidence act is to be made applicable under SIPA, particularly to common professional like myself, which is not legally. Yes, I do agree with you 100%. I do agree with you 100%. It's quite complex. It's quite complex. Even the law, the court themselves have to consider. That's why I say if you want to integrate I would say the oral evidence, the pro evidence rule or evidence act to be, then it's going to be a bit of too demanding, I would say. And looking at the nature of the adjudication itself, SIPA, I think, to me, I personally think that it should not be. It should not be. Furthermore, many of us are not legally trained. So we have to handle the issue of pro evidence rule. It's not that straightforward. I do agree with Surveyor Nas.
All right. Okay, so we have another question. When talking about small projects awarded without written form of contract, so what is your advice, both speakers, if there is a dispute, either refer to SIPA or is there any other means that we can refer? right? So talking about small projects, no, without written form of contract.
Okay, just I answer. Okay.
Yes.
All right. Okay. If there's no written contract, there's no SIPA lah. As simple as that lah. Because SIPA only recognize the written contracts. So that's it. So over to you lah, Mr. Dr. Zul.
I think if that case, I think the most, I would say the most appropriate is to mediate lah. Yeah, apart from going to court. Since as you mentioned, the small contract is a small project. Yeah, and if the best is to mediate, provided both parties wanted to agree to go for mediation lah. Yeah, I think I just want to share with you, me and Surveyor Eddie, we had concluded one mediation case earlier this year. Yeah. We conducted a co-mediation exercise. The issue is one of the party wanted to mediate, but the other party are kind of hesitant to mediate. Yeah, so they want to based on the, I would say, so in the end of the day, I would say that the mediation process does not come up with a settlement. But I think that the mediation itself is successful, but the parties are not able to come up with a mediation settlement. Yeah. Because both parties are not into it. Yeah, one of the party wanted to mediate, but the other party kind of a bit of hesitant. So that is one of the things that you have to consider when you are going for mediation, where both parties have a clear mind that you want to mediate. Yeah.
Yeah, true.
Right. Okay. Any other question from the floor?
Surveyor Rizwan Yahya.
Yeah. So
Neutral aspect is very important for conducting ADR and mediation in order to avoid bias to party. That's right. That is totally right. Yeah. We're talking about a natural justice. That is the mantra that the adjudicator, and also the arbitrator need to uphold. Yeah. Natural justice is a very critical issue. If you look at the trend of the cases that have been referred to court on challenging the adjudication decision is only based on the natural justice. Yeah, that's why it's something that the adjudicator or even the arbitrator need to be very careful in deciding or in managing the adjudication arbitration proceedings. They have to be very careful. They have to give both parties opportunity to present their case. Yeah, sufficient time for them to present their case. Yeah, sufficient time to submit their evidence. Yeah, there's something that the adjudicator, the arbitrator need to play very wisely. Yeah, and also to take care the issue of natural justice. Yeah.
all right. Oh, and thank you, Prof. Nasim, for highlighting to refer to the standard terms of construction contract for renovation and small projects, especially for the case with Mr. Wong that highlight earlier.
Yeah, I do. I think agree with Professor Nasim with regard to the plain language as well as small. I think most of the issues is on the interpretation. Yeah. So that's why we need to have a plain language contract in order for us to both parties to understand the contract by the purpose of the contract, the interpretation of the contract as well. And having said that, there are quite a number of small contract which has no proper contract per se. So by adopting this form of contract for small contract, I think that's one of the way forward. Yeah.
All right. Okay, we have another question here from Encik Muhammad Sufyan. Since mediation should be conducted in privacy, how can we have e-mediation in Malaysia? All right. So this one we're talking about secrecy.
Yeah.
So, all right. So, Eddie, can you share with us?
I think it's quite straightforward when we conducted the e-mediation, because e-mediation platform will be used like we using right now, the Google Meet, WebEx and whatnot. So you can choose to have a session in your room alone, together with the parties at another location at the private room. That's all. I think you keep yourself in private, then you can keep the session secret and confidential, of course. So I think it's no issue in terms of e-mediation, because I just share one of the webinar conducted and presented by the IR Harbans Singh, in the COVID-19 itself, during the duration of the COVID, he mediated quite numbers of e-mediation because orang tak boleh keluar rumah kan. So they conduct via WhatsApp, ada via WhatsApp pun ada. Via WhatsApp or via ni lah, video conferences. Thank you. So I think no issue lah.
Yeah, it is doable. I think even now also AIC is try to promote pro bono mediation by way of online mediation. I think both of us has signed up to become among the mediators for that. So basically, yeah, it is doable. Yeah, but I mean being trained as I would say as a traditional mediator ourselves. I have a bit of skeptical having the online mediation because being trained as a mediator, you have to know how to pose your questions, put how to your body language and so forth. I think that's something that needs to be taken care of as well. Even when you are having the online mediation conference, yeah. So coming back to your question, yes, it is doable, yeah.
Right. Okay. This is not exactly a question to the speaker. Yes, Dr. Rizwan, we will send you the notes and also the recording of today's session through email, inshallah. All right. So, any other question from the floor?
I think there's one question. I think it's not a question. It's an answer.
Yeah. Oh, okay. A question here. How strong is client needs statement in design and build contract can be used when the contractor refuses to execute the additional work which compulsory for the completion of the project with no additional financial gain? This is a question by Mr. Iqbal. Right. So I think Dr. Zul, you can start.
I'm reading the earlier question. Okay. How strong is client needs statement in design and build contract? Refuse to execute the additional work which and additional work. So coming back to I think for Mr. Iqbal, it's not a matter of need statement and so on and so forth. It's a matter of what's stated in the contract. So that is something that needs to be understood by all. So as an adjudicator arbitrator, we are bound by what has been agreed by the parties in the contracts. So if the contract states clearly that the need statement is integrated, then it is supposed to be integrated. Then the arbitrator adjudicator need to go through that design, that need statement, depending on what's stated in the contract itself. Yeah. So it's not about how strong it's a client need statement. It's depending on what the contract says. Yeah?
So what is included in the contract? Yeah.
Yeah.
All right. So Adi, do you want to?
Yeah, I agreed on the statement of Dr. Zul. Actually, it's very simple in terms of interpreting the construction contract, as well as we know or we draw the line with the we call it the four corner rules. Whatever inside the corner, inside the box is the obligation of the contractors to do the works. So anything that's outside the box, that will be the additional, and of course the additional cost to the contractors to build it in design and build contracts. So coming back to the contracts, we need to draw the line clearly so that we can understand and interpret the same page as the client, so that there is no dispute in terms of interpretation of the obligation under the construction contracts.
All right, thank you. Any other question? You can just directly pose the question to the speaker. Anyone? Right, so if no, so I'm going to pose a question. This is for Dr. Zul, specifically on arbitration. So does the law actually prohibits, all right, any types of disputes being resolved via arbitration? Is there any limitation?
Yeah, being an ADR by itself, there are certain limitations, of course, yeah. we're talking about SIPA is covered under a few provisions on Section 3, Section 4, and so forth on what can be referred to SIPA and adjudication. So same goes with arbitration. Yeah, arbitration is a matter of public policy. Yeah, so that is the extent of it. It does not state it clearly, but it mentioned about public policy. So meaning that the public policy, the issue like criminal law is not arbitrable. Yeah, and arbitration is more on commercial in nature. But of course, the thought issue, negligence, is arbitrable. So so the mantra is public policy. If the public policy does not allow the case to be arbitrated, then that is something that beyond the jurisdiction of the adjudicator to decide.
Okay, thank
The
you, Dr.
arbitrator to decide. Yeah.
Yeah. All right. So I also have one question to Surveyor Adi. So what is your take on this statement? Yeah. I've stumbled across one article that stated one of the disadvantage of mediation. Right. It stated that parties may actually take advantage of mediation process to uncover, all right, other party sides with actually no real intention to settle the issue here. So what is your take on that?
Yeah. Okay, a good question from Puan Suhana. See, actually, the mediation process itself actually voluntary in nature. So it's up to the parties to go for the mediation. So as long as there is an agreement by both parties to mediate, so it's no harm go for the mediation. So and of course through the process of through the proceeding in the mediation, there will be the reveal term of issues from one party to other party, and of course during the private caucus with the mediator alone, there will be some issues or statement from the parties to make things even worse, kan? So that end of the day, so the mediation will be terminated without any positive agreement lah. So and of course as compared to the adjudication, which is more on procedural proceeding kan, macam mediation ni more bersifat voluntary bersifat voluntary.
Alright, Dr. Zul?
Yeah, betul. I do agree with the statement. So basically, I've experienced it myself, where the parties mediate for the sake of try to prolong the time and also try to delay the process of so-called resolving the issue. Yeah, so memang ada lah where the parties, one of the parties is trying to abuse the process. Memang ada, yeah. But of course, it is something that beyond our control lah. As a mediator, we try our level best to mediate. Since we are appointed as a mediator, we try to mediate and try to come up with a settlement. In the end, it's the parties to decide. You have to know that, you have to be aware that mediation is the one that we practice in Malaysia is facilitative mediation. We are merely facilitate the process. So in the end of the day, it's the parties. Yeah. If the party decide not to, I would say, not able to agree on it, there's nothing much that we can do. Yeah, the mediation failed, but the mediator does not fail. Yeah, that's the fact that the party.
All right. Okay, so there's a question by Encik Abdul Ghani. So what implication if client receives SIPA and how to contest the contractor? Okay.
There will be another 2.0.
To answer that.
I will answer that. Okay, so short answer from me.
Yeah.
So I think through my slide, there will be the processes under the SIPA proceeding. There under Section 6, if I'm not mistaken, there will be the payment response. Payment response. So the payment response under Section 6 is the arena or the avenue for the party that receive the SIPA claim from the unpaid party.
Alright.
So that's it.
Okay, thank you. I think we are going to take one last question here from Mr. Wong. Cost of mediation and arbitration agreed in advance, shared equally, or the losers to pay? Right. So Anyone can start?
So on the mediation, I can share the mediation. Okay, under MMC rules, the parties need to deposit the
Okay.
full fees to the MMCs
Alright.
prior the mediation conference.
Hmm.
Then only the mediation will start.
Hmm.
So need pay in full.
Okay. Dr. Zul, on arbitration?
I think
Silakan.
okay. I want to answer one question from I think from Cik Gani when he asked about the client receives SIPA and how to contest the contractor. So basically, once you receive the form 1 ataupun
The claim.
the payment claim, so you have the opportunity to discuss with the contractor if you're on the client side. So and also you have the if you want to contest, then you should go for the form 2 lah. Then you contest lah the form 1. So coming back to question on the cost of arbitration, basically the costs agreed in advance shared equally or the loser. So basically so far based on my experience, it's based on the losing party pays. So basically, I think same go to the adjudication where the payment based on the event, meaning that so if the loser lose the case, then they have to pay for the arbitration cost of the proceedings. Yeah.
All right. So this is actually from Dr. Rizwan. Our mediator is more likely as a technical counselor. All right. So what do you think? Is it right? Yeah.
So as I mentioned to you earlier on, the mediator is not a counselor. We are merely facilitate the process. We are not giving any advice. We are not decide on behalf of the parties. Yeah, we are merely facilitate the process. The parties decide where to go, how to go. What to decide and how the dispute is settled. Yeah. So as a mediator, we are merely facilitating the process. For instance, we try to explore the potential solutions, by best option available or BATNA, or whatnot, worst case scenarios, things that is going to happen if the case is not settled. So we extract out that answer from the parties themselves. Yeah, that is our role as a mediator. Yeah, so we are not basically counselor. Counselor is like giving advice, kan? So there's something that is a bit no lah for the mediator. We does not provide any advice. Yeah, even if the party decide also is the we have to be very clear on that. Normally during I think kan Mr. Edi kan,
Yeah.
we made it clear during the preliminary meeting. We made it clear that, and also I think even during the conference also, we are going to keep on emphasizing that we are not here to give any advice, any legal advice, and on that issue.
Yeah, great.
So we have the last question here because time is running out. So the last question to both panels from Sabina Rahim. Can we completely discount the involvement of lawyers in arbitration proceedings? And another question, if a client can hire a non-lawyer to manage its SIPA claim from A to Z, how about arbitration? All right, so question for both speakers. Anyone can start?
So basically, I'm not trying to say that completely discount the involvement of lawyer. It's a very strong statement, kan? So it's like the party's autonomy, meaning that the parties can decide whether they want to have a lawyer to represent them as a legal counsel, or they want to have those who are not lawyer but who are quite familiar with arbitration. Yeah. So I think we also been referred to by a few of the contractors to represent them, even though we are non-lawyers, so to represent them in arbitration, kan. So it is up to the parties to decide. Even though the Arbitration Act and also the SIPA Act does not provide does not say that the lawyers should represent the parties. Yeah, it's up to them. So even though if the party wanted to represent themselves in the arbitration adjudication, also it can be done. Even having said that, SIPA is meant for apa nama tu? It's something that do it yourself. So mean that if the party wanted to involve in SIPA proceeding without having lawyers, then it can be done. Yeah, same go to the arbitration as well. But yes, cuma if you are not familiar with arbitration, you're going to be a bit of hiccup lah to understand the procedure and so on and so forth. Itu saja.
Alright. So BID,
Yeah.
your last take.
No lawyer in the room, I hope.
Yeah, agreed on the Tezul statement. I think because as compared to the education and arbitration is more, to me, is more like traditionally presented by the lawyers. So that's people tends to go for the lawyer services instead of claim consultant and whatnot lah. So traditionally, yes, because in fact, in my current organization, is there any arbitration cases that from the contractors or the vendors, we straight away go to the legal department, seek advice, engage lawyers, not engage claim consultant instead. But I see, I saw few cases in my adjudication that there is not only lawyers, there will be the claim consultant represent the parties, especially on the claimant in terms of serving the notices under SIPA. Yes.
Being experienced in handling cases, arbitration, adjudication, basically ada juga lah kelebihannya having lawyers ni. Kelebihannya adalah if you look at being lawyers, normally their document is quite intact. Yeah, the evidence, the way the narrative being presented is quite good basically. I think when I initially started as adjudicator, I'm quite so-called skeptical to have lawyers as part of the party's representative. But as time goes by, I can see that if the parties appointed lawyer to represent them, I think the document is quite well prepared, kan? I'm not sure whether Eddie agreeing or not. So I said, it's well prepared, well justified, and the case laws are there. It's so easier for us as adjudicator to focus on the substantive part, to go through the case law itself. But of course, it's up to the parties. It's up to the parties to have lawyers as their representative.
I agree.
Okay. So actually with that mark the end of the discussion session. We sincerely hope that we are able to cater and answer questions with regards to ADR, inshallah. Right? So ladies and gentlemen, may I thank you very much for your participation. I would like to extend warm wishes and thank you to both of our speakers for spending their time here. Right? And before we end, I would like to invite all participants to switch on your web camera, so that we can take a group photo. Right? Can you do that? Oh, dah bersedia dah tu, ha? Okay. Right.
Kejap, kejap.
Okay. Okay, angle betul ya?
Okay, itulah nak.
Okay. So everyone, let me change the setting first. Oh, camera not working. Alamak. Okay. All right. So hopefully everybody is here. Let me change it for a while, guys. Sebentar ya.
Boleh.
Nak adjust dulu. Kang nanti Kang tertinggal gambar Kang.
Saya dah keras tu sini.
Okay.
So I think just while Sue is trying to I think I agree with Chief Foy lah. Lawyers are important to sniff out the errors. Yeah. I think I do agree with you on that.
Both lawyers and the technical actually
They have their own, I would say, apa nama tu? Dia punya kelebihan lah.
one ability lah, and a special ability and character. So when we combine together, it's very superb lah. Superb combination, technical and lawyers, law background.
Okay, everybody, huge smile. Okay. All right. Okay, one more picture. Okay. All right, Alhamdulillah. Okay, we're going to share the picture with you, and we're going to email it, inshallah. All right. So, on behalf of the organizers, I sincerely hope you have the Burak Liha. Okay, so I'm going to share with you a link for the attendance, all right, and also attendance link, and also please it's very important before you leave your room. Okay, please fill in the evaluation and attendance form, especially very important because we need it to secure your CPD points and also your training hours. All right. So thank you again. I apologize for any shortcomings throughout the session. Thank you for spending your time with us. Thank you for both speakers for sharing your take and input on ADR and inshallah. So we're going to have another session ahead. So we're going to see you guys again. Inshallah. Assalamualaikum.
Thank you.
Assalamualaikum. Thank you guys.
All right. So again, reminder, please fill in the attendance form. Yes. All right, wait. I'm going to ask the organizer to open up the form. Yeah.
Pakai suit tu, Dr. Zul.
Tak habis lagi, weh.
Suit tu. Lapar ni.
All right, for those who cannot access the form, can you please wait for a while? The organizer is trying to fix it.
All right, I think you can now access the form. So hopefully there's no problem. So if you have any problem, just text us. We are here. Yes, inshallah, we can give you the slide. So make sure you fill in your email address in the Google form so that we can send you the copy.